Giano Sevilla Jr.
Yes, ma'am.
And Mr. Sevilla, the best you can, would you raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Mr. Parker, will he waive the formal reading of the motion?
Here we go.
Mr. Sevilla, in clause number 2239617, I have a motion to revoke your community supervision. Shows that you were placed on probation November 30th of 2022 for the third-degree felony offense of stalking. And that was a 7-year term in prison that was probated for 10 years. Is that correct?
Yes,
The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of criminal mischief, May 23rd of 2026 in Orange County, Texas. And is that true or not true?
That's true.
Count 2 alleges that you committed the offense of stalking, May 22nd of 2026 through May 28th of 2026 in Orange County, Texas. And is that true or not true?
That's true.
Count 3 alleges that you failed to, it's really the same.
It is, Judge. This was a motion that was filed rather quickly at the court's request, so I put everything.
Yeah, no, that's fine. I appreciate that. I'm gonna skip 3. Count 4 alleges that you violated a term and condition of your probation by prohibiting the possession of a firearm, in that you were in possession or observed in a video displaying and possessing a shotgun and a red shotgun shell in November of 2025. Is that true or not true? Count 5 alleges that you violated the term and condition of your probation that required you to have no contact with the victim, Cynthia Gonzalez, and that on May 23rd of 2026, you sent text messages to Cynthia Gonzalez in violation of that order. Is that true or not true?
That's true, Mom.
Count 6 alleges that you are behind in your court assessed fees as of June 2nd of 2026 in the amount of $349. And is that true or not true?
That was complicated. I would always pay. I never had problems paying.
Well, it was just as of that date. So that's fine. I'll put not true for 6. All right. Did you enter your pleas of true to counts 1, 2, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
That's true.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 5 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation. But I'm not going to do that today. I'm going to reset your case for a sentencing hearing, ask the probation department to do an updated report. Obviously, if there's any evidence with regard to the firearm allegation in count 4, we can hear that. It shouldn't take too long if you want to have somebody here on that.
Well, Judge, and just so you're aware, I did contact Orange County DA's office last week. They do not yet have that case. In anticipation of these pleas of true or not true, I reached out to them. Also reached out to Detective Taylor at the Bridge City Police Department. I would like to bring him at the sentencing regardless of these pleas for the court. I think it'd be important based on the fact that he's on probation for the stalking. It's the same victim, Miss Gonzalez, in both cases. I've handled it since the beginning of it. So if you would allow us a little bit of extra time, I'd like to bring that detective
Sure.
as well.
And we could do that on a regular morning
Yes,
docket,
that'd be
but
fine.
yeah,
Just
that would be.
you note I'll have a witness or two.
Okay. Do you anticipate witnesses?
Just my client.
Okay, so we'll just make a notation that there will be witnesses and maybe put this one at 11 for a sentencing, and we'll get an updated pre-sentence report. Anything that you think is important for me to know, get that information to Mr. Parker.
I'll give him later.
I understand.
Yeah, just you'll talk before sentencing and he'll present all that to me on your behalf when we come back. All right, go back with the bailiff.
Come see. You get this.
Are you Arlington Wood Jr.? And Mr. Wood, in cause number 25 DCCR 1650, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements. That's from July 30th of 2025. The indictment alleges that you were also previously convicted of burglary of a vehicle, a third degree, burglary of a building, a second degree, another burglary of a vehicle, third degree, and an unauthorized use of a motor vehicle, a third degree, on January 27th of 1986. And after those were final, you were convicted of theft, a third degree, January 22nd of 2019. You guys have marked off second degree, but would it not be a habitual?
It's not habitual because
It could be because they did not include in the indictment the underlying sexual assault offense that caused him to have to register.
Okay. So,
That would be a notice I would make
A
on my
notice.
own.
and that would make it a habitual, correct?
Correct.
So, Mr. Wood, I want to make sure you understand that if you go to trial and you're found guilty and the state files that notice of enhancement with the prior felony conviction that's not in this indictment, that you could be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here on the tablet that you've signed with Mr. Parker that shows that the district attorney's office has made an offer. If you wanted to enter a plea of guilty, looks like to go forward probably on count one only for a 10-year term in prison. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. Do you understand all of that? Sorry.
Yes, ma'am, I understand.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Is there any reason to believe that that offer would change, Ms. French?
Mr. Parker may have information for me that might cause that offer to change. Can we reset? How long, Mr. Parker? What do you say?
I mean, I don't know what I'm gonna provide you other than what I've told you. I'm not gonna have any documentation. I mean, he's on parole, Judge. He has 2 types of cancer. He has some health issues and quite bluntly, anytime he gets, he thinks is a death sentence. And so, I mean, that's his position, understand it. But I don't know if his position is going to change.
So let's just do this. So, Mr. Wood, I'm going to place your case on the trial docket. If anything changes between now and then, the attorneys can let me know. We can get you back in here sooner. Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Parker, you're released. Mr. Wood, we will appoint someone today. They should be out there to see you very soon to begin preparation for trial.
And this is the moment that changes the entire equation. The judge is warning him that if the state files the enhancement notice and he qualifies as a habitual offender, the potential punishment could jump to a minimum of 25 years, with a maximum of 99 years or life. Now he has a choice. Accept the existing plea offer, or take the case to trial knowing what could be at stake. Would you take that risk?